Hi, Daniel O'Connor with the Brighton O'Connor Law Firm. Today I'm talking about what happens if you die without a will. As a housekeeping matter, there's a lot of different things that could happen if you don't have a will. So if you die without a will and you own no property at all and you don't have children, it's probably not a big deal that you didn't make a will. Now when I say no property, I mean literally nothing. You don't own any real estate, you don't have any money in the bank that didn't transfer on death. You didn't have a lawsuit pending where you were going to collect a lot of money. If none of those apply to you, then maybe it wasn't a big deal that you didn't have a will because you don't have much of an estate to probate, and your estate doesn't have to be probated. But if you have an estate to speak of, which means you have any amount of money, you have any real estate, or other assets that need to be a business or something like that needs to be transferred, or if you have children that you could have nominated guardians for, and you don't have a will, you have some estate and matters that have to be taken care of. With respect to your property, the way that someone is appointed to handle that is a process called administration. It's called, and you have someone has to file a petition to become your administrator. If they don't, and there's not some other recognized means of transferring an asset, then the property is just going to sit there and nothing's going to happen. It's important to note that if you had a power of attorney while you're alive, that power of attorney after your death is no longer valid. I tell people a power of attorney dies with you, and they can't transfer assets after your death. Now back to an administration. An administration is the process of resolving an intestate estate. An intestate estate is an estate where the decedent, the person who died, had no will. And it's a one-size-fits-all process prescribed in the laws of the state of Georgia. And they're laid out in OCGA Title 53, if you're interested. So, who gets to be your administrator? Well, there's an order of priority, and the law prescribes that. Your spouse, even if you've only been married for 1 week, is the top of the line priority. They have the best chance of being appointed as your administrator. Next are the children. After that are other eligible persons, creditors, or the county administrator, if none of that works out. What happens if there's a disagreement over who should be the administrator? Well, there'll be a fight in court, and it'll go through, and a probate judge will decide who the administrator is, based on who the order of priority, cross-checked against, who's qualified to serve. Before an administrator is appointed, who has to get notice of that? Well, all of your heirs have to be noticed, and your heirs are, there's a table that you can look up, but your spouse is always an heir if you're married, and your children, if you have any legal children, that means your biological children or adopted children, those groups will always be heirs. And a spouse will be at minimum be entitled to 1/3 of your estate, and 1/2 if you only have one child. And if you have more than one child, the spouse gets 1/3 and the children split the other 2/3. If you're not married, the children get everything. If you're married without children, your spouse gets everything. And it doesn't matter if your children are estranged from you. It doesn't matter who took care of you. None of that really matters. It's a one size fits all. And if you don't have a spouse or children, then there's an order, there's a sequence. Grandchildren, if you don't have any descendants at all, it goes to your parents and then your brothers and sisters and so on. We could go on forever on that topic. If everybody agrees on who the administrator is, and that's a big if every heir agrees, administration may not be that difficult of a process to start off with, at least getting appointed. Now, getting appointed as administrator is just the first step. If there's an objection, it can take months and months or even years before an administrator is even appointed to get started on the estate, because you have to go through hearings and possibly discovery, just like a court case. So in lucky cases, fortunate cases, everybody agrees on who should be the administrator and they move forward from there. So once the administrator is appointed, what happens then? Well, the administrator may have to post a bond, which is like an insurance company that insures your estate, which again, those are the things that you own at your death, and your heirs. Insure them against your negligence, or if you just blew the job and lost a bunch of money for the estate, it's an insurance policy. Now your heirs can waive that in writing if they all agree and you publish notice and there's no objection. The other thing you might have to do is file reports and inventories with the court, and that's another thing that your heirs, if they unanimously agree, can waive. And you may also have to get permission to sell anything, and that's also a thing your heirs can waive. So you can see there's a big difference between uncontested administrations and contested. The problem is you can't always predict what the case is going to be, and it really depends on your family dynamics. The administrator also has to run a notice of debtors and creditors. You've probably seen the notices in the newspaper. For 4 weeks, you have to publish a notice, basically inviting your creditors to make a claim against you. You're giving them 90 days from the last publishing date, or 3 months, I think the law says. And if nobody files a claim within that 3 months, they may have waived their claim unless they have a secured interest of some sort. Okay. And if there are claims, the administrator has to try to resolve those. As you'll see, creditors have a higher priority than the heirs when it comes to distribution of the property. So let's say you do everything. You marshal the assets. That means the administrator marshals the assets. That means they find all of them. Hopefully, they know where they are. A lot of people say, if I don't have a will, is the estate going to get on my property? Usually not, but if the people you leave behind don't know what you have, then that's possible. There's billions of dollars in unclaimed property in our country. Probably $1 billion in Georgia was the last number I saw, of property that nobody ever claimed. You don't want that to be your family that didn't get your property. So that's where planning comes in handy. Even if you have a will, that could happen if your heirs don't know what assets you have. And that's why it's important to work with a planning attorney who can help you keep a log of what you got. So once you pay all the debts, you found all the assets you're gonna find, it's finally time to distribute the assets. So who gets them? Well, again, it's the one size fits all. The law prescribes this. So the first in line is there's a thing called a year support that you can make a number of other videos about. Widows and minor children, if they're not provided for otherwise adequately, have a right to ask the court to set aside a year's support from your estate for them. That's beyond the scope of this video, but that's the top highest priority claim. And it stems from, I think, medieval Europe, where the idea of a year's support for widows and orphans came from. Next, funeral expenses. Funeral expenses are next in priority. Then other necessary expenses of administration. So your administrator is entitled to a fee for being your administrator. And this could be up to 5% of your estate or some other contracted amount that they've worked out with the heirs of the court, as the case may be. Next are the reasonable expenses of your last illness. Next are unpaid taxes or debts to the state or the United States. Next are judgments and security interest. And then finally, all other claims. And then only after your estate has paid all these things, do your heirs get their share, which I went over the share that each type of heir gets. So you can see, administration is basically a process where you somebody sues the dead person's estate on behalf of the creditors of the estate to give them an opportunity to make their claims. This whole process is designed to protect creditors, and then ultimately, after all the creditors are paid, to distribute the money to your next of kin in a preordained amount. One size fits all, as I say, which may not be the case. So you can think of some situations where this would be disastrous. Let's just say you're married and you have minor children, and you own half the house and your spouse owns half the house. That's not the joint tenancy. If you die, your 1/2 is getting split 1/3 between your spouse, and the other 2/3 are going to your children, who didn't pay a dime toward the mortgage on the house. Is that what you want? And I haven't mentioned this, but minor children have to be appointed a guardian ad litem in these cases. So they're represented by an attorney who's going to make sure that they get their share. But it's probably not in their best interest to get their share of an asset like a house that they're not paying for. And they have no right to sell because they're minor children. And therefore, anytime they ever want to sell, or refinance the house or something, they're going to have to get permission from the court. So, and there are a number of other situations you can imagine where not having a will would be a big deal. Now, sometimes families get along and they come to an agreement, and that makes the process easier if there's unanimous agreement on what to do. They have to jump through a lot of hoops, but an agreement makes things much easier. And so a perfect process where everybody agrees, it's a small, simple estate, maybe just a house or something. The shortest time frame possible is really, in Georgia, about 6 months. That's if you've got an attorney that's on the ball, you've got heirs who all agree on what needs to happen, and an administrator that takes care of business, and no big creditor claims. So this is just a perfect small estate. A bigger estate with more different assets is going to take longer just because there's simply more to do. Estates where there's creditor claims or pending lawsuits are going to take longer. And some estates where the heirs just hate each other, those could take 10 years or more. I'm not exaggerating. There are estates that are just open forever because the heirs simply fight about everything. And they end up spending all the money on administrator fees, court fees, lawyer fees, and lost value in property because nobody gets to enjoy what the person who passed away left for them. So, and then assuming the administrator does everything, everybody's satisfied, then the administrator can petition for discharge, which they often want to do so that they're not personally liable if somebody comes back later and claims they did something wrong. So we've sort of covered the administration process. There are more pitfalls than what I've said, but I hope this is an overview that lets you know kind of what will happen when you die. I don't want to be too dramatic about it because I handle administrations for people. Most of the ones I handle are uncontested type just because that's, I'm not a huge fighter. But, and a lot of those we're able to handle, in less than a year. But there are many that don't work out that way and are truly a disaster. and people who end up getting property that they were not intended to get. If you don't have a valid will, a will that's validly made, it doesn't matter at all what the person who passed away wanted. That's irrelevant. Unless it's a written will that's properly witnessed, has the right stuff in it, the laws that I just described in short are the ones that are going to apply. So I hope you found that educational. You may be fine with that. There are some people that, are just like, whatever, I'll let the state rules apply. If that's you, that's fine. If it's not, we'd love to help you get a plan that meets your goals, what you want for your family, and the process, what you want the process to be like for your family. You may not be able to come up with something that's just a piece of cake, but we could certainly come up with something better than the administration process. So until next time, take care.